Kimberly, we've got a few questions from readers that we've received over the past few weeks. And one of those questions is special resolutions. Perhaps a good starting point is to first understand what is a special resolution and in what cases a special resolution needs to be passed.
No problem. So the prescribed management rules in terms of the Sectional Title Schemes Management Act sets out an agenda that needs to be covered in your annual general meeting. Anything that is not on that agenda would be passed in terms of a special resolution in a special meeting. So things like that would be, for example, addressing how the body corporate will deal with any legal fees that are imposed on the body corporate, or if one wants to pass an interest resolution stipulating the interest the body corporate is entitled to charge, or for example if they would like to extend the size of the body corporate swimming pool or build a jungle gym, anything along those lines that isn't day-to-day business would require a special resolution.
So how does a special resolution get passed? And the question really that we received was, how do we dispute a special resolution and the amount of time given to do that? You've got some insight into this question.
Yeah. So what we do is the body corporate would be required to give all the owners or all the members of the body corporate notice, specifically 14 days notice in order to attend the meeting.
Okay.
Owners are entitled to waive their right to notice, in which case they wouldn't attend the meeting. However, if you do not waive your right, you are obliged to be at the meeting. If you are not, so then the meeting would be required to meet a quorum, and the value per owner would result in you need a 50% or more value to pass the resolution.
Okay.
If the body corporate doesn't meet the quorum that they need in order to pass the resolution, they would not be entitled to implement the special resolution passed for a period of 1 week. Thereafter, if quorum is still not met, they would be entitled to they would be required to hold another meeting to rediscuss what is needed for the special resolution or what is wanted out of that special resolution.
Can this kind of thing be a delay tactic employed by owners within a sectional title complex? Because I'm sure that happens.
Yeah.
We don't want to increase for whatever reason, we don't want to pay this, we don't want to increase the size of that, whatever it might be. It's not day-to-day stuff. So can owners just basically abscond and say, we're not going to allow you to form a quorum? So can they hold the body corporate and its trustees, the trustees itself, to ransom?
Yeah, it is very difficult for body corporates to pass such resolutions. They have a lot of difficulty contacting all the owners
Sure.
and getting the quorum required. And this is, I wouldn't necessarily say it would be a delay tactic. Perhaps some owners would be spiteful in that sense. However, most of the time it's just day-to-day life that they aren't able to get the quorum. In such an instance, if they are having extreme difficulty, the joys of the Community Schemes Ombud Service Act now puts the Ombud in a position to assist body corporates who cannot reach quorum. So in such an instance, they could then approach the Ombud, who would assist them in passing the quorum that they require in order to proceed with the action that they want.
Fantastic. Well, there we go. I think that answers that question very well. Question number 2 from a reader that she's got quite a question here, so I'm not going to read the entire text, but some background. She was previously living in one complex where there was a set of rules, and it was the same managing agents, and she really enjoyed living there. So now she moves out. And what happens is she moves to the new complex, which she finds out are being managed by the same managing agents. Her assumption is that the same rules will apply and she will enjoy the same existence in this new complex. So this is her reason for moving in, her sole reason, I suppose. And what she seems to find out when she moves in is that the rules that she signed up for are not being followed. So whatever the sectional title rules were previously implemented and still are in this new complex are just ignored. So what she's done is she's gone and complained, and she says, look, I'm not happy with this. What are we going to do about, enforcing the rules that are in your rule book as such? What does she do in the instance where the trustees of the just decide to say, nah, we don't care, move along now. We're going to do stuff as we've gotten used to doing it. What sort of recourse does she have now? Because her reason for moving there was for those rules specifically. So how do you hold that your trustees to account to their own rules?
So the trustees are obviously the ones who are entrusted to perform and exercise the obligations in terms of the Act. The trustees have, if for example the trustees have difficulty in imposing the rules and ensuring that they are complied with, then the Act sets out certain functions or certain possibilities that they could follow for members that aren't complying. But if your problem is that the trustees are the ones that are not complying, then an owner is entitled, in terms of Section 9 of the Sectional Title Schemes Management Act, they can impose, well, they can proceed to the court for assistance in such a matter. So they would give the body corporate an opportunity. First of all, it would be advisable to start off by requesting a meeting and stipulating that they're unhappy with how the rules are not being enforced. If the trustees still don't enforce the rules in the way that they are supposed to, then an owner can proceed to court and request the courts to impose action on the body corporate. And ultimately the court would start off by authorizing that the body corporate be assisted by a curator ad litem, and they would then take all of the responsibilities of the trustees into account and ensure that the process is followed. And from there onwards, the court will decide whether it's necessary for the curator to be appointed full-time or whether it's just a stepping stone to push the trustees in the correct direction.